And welcome back. This is Newstalk. Once again, our guest is Utica Attorney Mark Wolber. It is not the first Sunday of the month. You were on vacation last week, so he is here today to answer your questions. 793 WKTV. And before we take our first question this half hour, you brought back a trivia question from Jamaica, right?
Yes, this is interesting. What is the 3-digit emergency number in Jamaica? It is not 911.
And I was guessing maybe 666 or 000, but it is
119.
no reason why, right? So if you go to Jamaica, dial 119.
Yeah,
if you
don't
need
dial
emergency.
911. I didn't know what'll happen. I didn't try it.
Thanks for that. Hello, Katie. What's your question for Mark this morning?
Mark, I've got a quick question for you. To prevent a home from being taken, should you go in a nursing home, is there anything that doesn't require the 5-year wait? Would it be like to deed a home over to a child with the use of the home?
Yeah,
what is the best way?
There's 3 situations where you don't have a 5-year look back. One is to a child. It can't be a grandchild or a nephew or niece. It has to be a child who has lived there at least 2 years prior to the transfer.
And how do you prove that, though?
Bank records, bank address on your bank statement, credit card statement, anything like that. The second situation is to a disabled child. Mm-hmm. And remember, disabled child doesn't necessarily mean someone is mentally disabled. It could be a physical disability. So you can transfer it to a disabled child, then there's no 5-year wait. And you can transfer it to a sibling, and as long as the sibling has lived there at least 1 year and has some interest in it by contributing to the cost. So sometimes you have a brother and sister living together, or 2 sisters. One of them goes in the nursing home. It's in the name of the one who's going to the nursing home. That one can transfer to the other sibling and then become eligible for Medicaid the next day. So those are the 3 situations: a child, a child living there, a disabled child, or a sibling who's lived there at least a year.
And if you want to hear Joe's question, you're going to have to plug in your ear there. You're losing it.
Yep.
Hello, Joe. What's your question for Mark?
Yes, my question is, if you're being released out of jail and you have an active warrant, but you was in jail for over a year, and when you come on, they have a warrant on you, is there a statute of limitation before them to prosecute you instead of that warrant being issued?
No, the warrant, once a warrant's been issued for you, that would stay the statute of limitations as far as the prosecution goes. So if you're getting out of jail and there is a warrant, normally what happens is there would be a hold at the jail and they won't let you out, and they would request that law enforcement agency in that community to pick you up on that warrant. Now, if they give you, I don't know how many days, if you're not picked up, then they will release you. If you do get released and you're aware that there is an outstanding warrant, what you need to do is go to the court which issued the warrant and then go in front of that court, and then usually what happens is and you're probably going to want to do this with an attorney, but usually if you go to the court, you surrender yourself, you explain to them the reason that you couldn't come to court was because you're incarcerated on a separate charge. In most cases, the court will withdraw the warrant at that point. Court could make you post bail, but could also withdraw the warrant. I've had many situations where that happens. In fact, someone's got a warrant, they call me, say there's a warrant out for me, we go to court, and the court will withdraw the warrant as long as the person has voluntarily appeared. So that's what you need to do.
So definitely go to court.
But once they issue the warrant, then that stays the statute of limitations.
Hello, Bob. What's your question for Mark this morning?
Good morning.
Hi, Bob. Are you there?
Yeah.
Hello. What's your
good
question?
morning.
Yeah, I was wondering how long does the executor of a will have to transfer the deed if they're the sole only person that the house was left to, and what responsibility does he have to pay the bills if she doesn't have enough money in her estate?
Okay. There's really 3 questions here. The first question is, if someone dies and has a will, and the will leaves everything, we'll say, to a son, and the son is also the executor of the estate, there really isn't any time period that the executor must transfer the property from the deceased person using an executor's deed to himself. So there's really no time restriction on that. Most of the time you're going to want to do it sooner rather than later, but if there's a delay, that really doesn't cause a problem. The second part of the question really is, how long does an executor have to complete an estate? The general rule is you have 7 months to complete the estate. Now, that's only if there's other people involved, because no one's going to do anything the court isn't going to come after you if you don't complete the estate in 7 months. What happens is one of the beneficiaries has the right to bring a proceeding in surrogate's court to compel the executor to account. You cannot do that before 7 months have lapsed. So when 7 months have lapsed, if the estate is still not completed, one of the beneficiaries can bring a proceeding in court to compel the executor to complete the estate. The third part of your question is, what obligation does an executor have to pay the bills of the deceased if there are insufficient funds? And the answer is none. The executor has no personal responsibility to pay any of the bills of the estate. The executor's responsibility is to liquidate whatever assets there are and then pay the bills from those assets. So if the bills are, say, $20,000 and there's $10,000 in a bank account, the executor's obligation is to use that money to pay the bills. The problem is, if there are more bills than money, you can't pick and choose the ones you pay. You have to actually pay them on a prorated basis. So you have to sometimes get a court order determining how the payment should be made, because if you pay one and you don't pay the others, you have a preference for one, then you could be held personally responsible. If you mishandle the estate, you could be personally responsible. But if you handle it the proper way, then you have no personal responsibility for any of the bills in the estate. In fact, in some cases, it might be recommended that if you know that the estate is insolvent, then you just don't apply to court to be appointed, and you just don't do anything. Don't get appointed as executor, because it's going to be more work than it's worth to anybody. So
Beautiful.
that happens sometimes.
One more question. Hello, Joyce. What's your question for Mark this morning? Hi, Joyce.
Yes, I just want to know, is common law counted in your state?
I didn't quite understand you. I'm sorry.
Is common law counted in your state?
Is common law?
Oh, common law marriage?
Yes.
Oh, okay. Common law marriage was abolished by the New York State Legislature in 1925. So if you had entered into one prior to that date, then it would be recognized. There is no more common law marriage in New York except for those entered into prior to 1925. I will say, however, that if you have entered into a common law state in a marriage, common law marriage in a state that recognizes that, and then you come to New York is obligated by the full faith and credit clause of the Constitution to recognize that marriage. But you cannot enter into a common law marriage in New York State. To be married, it has to be by contract or by some official, either government official or religious official.
Beautiful.
Gives you marriage.
Wow,
marries
great
you.
questions today.
Yes.
That's for sure.
Very much so. Before we leave this morning, first of all, I want to say good morning to my 4 little friends, Chanley, Olivia, Kevin, and Jan Maria.
Okay.
And we want to wish them a Merry Christmas. And I also want to say to our listeners, first of all, thank you for listening and the kind comments you make during the year. Appreciate it very much. And I want to remind people, if you know someone who's going to be alone over the holidays, spend some time with that person. Just remember them, because while it's a wonderful time for people who have family and friends, it's a very difficult time for people who don't. So if somebody you know that's going to be alone on the holidays, just take a couple minutes, either call, stop over, and make it a little easier for them to get through the holidays, because it's difficult for people in these situations.
Well said. You should
Thank
also
you.
answer counseling questions.
I will.
Have a happy holiday.
See you after the first.
Yeah, that's for sure. Stay with us. We're back to wrap things up right after this.